everyone, and welcome to the next episode of the Speed Mooting Partners in Crime podcast. It's episode 33 today. We can't quite believe that we've been recording these this long for you. Please forgive us this week as we had to bring you an episode without video just because John is recovering from a little eye problem. So we need to keep him away from screens whilst he heals and recovers. But fear not, we still brought you a good episode this week, and it was an Ask Speed Squad special because we've been getting lots of questions from you all, which we absolutely love. So please do keep them coming. So in particular, the questions we answered were focusing on getting work experience and getting your foot into the legal industry. So we had a good chat about how to think outside the box to get some work experience and how to build up your connections. Someone asked me a question about my time as a commercial solicitor and how commercial advocacy compares to other forms of advocacy, so we had a nice little chat about that. And then we answered some practical questions about how to use a PSR, that's a pre-sentence report, for a plea and mitigation competition. So it was a good episode, we enjoyed recording it, and we hope everyone finds value listening to it. Welcome to the podcast. Hello everyone.
Hello, welcome to the podcast.
We are live.
I'm John.
And I'm Hayley.
You might notice something slightly different this week. If you're watching on YouTube or on one of the streaming services, there's no picture.
And no, we are not doing our best John Cena impression.
That was a good one, Hayley. That was a good one.
Thank you.
For those who don't know, John Cena says, "You can't see me." But of course you all know that. Ironically it is to do with what can or cannot be seen. I'm not particularly feeling great this week. I have a problem with my eye. Won't go any further than that. Long and short, my vision's a bit blurred this week due to one of the eye drops I'm on, so it's going to be A, difficult for me to see the screen, and B, you don't really want to see my eye either. So in the interests of keeping everything clean, we thought let's just do an audio only episode this week. I should be off my dilation drops next week, so hopefully things are back to normal. So hopefully it's normal service resume next week, but you still get to hear our voices, you're still going to get the same great value podcast, so we hope you enjoy.
Yep, and I think just a shout out to our dedication, and particularly yours, John, even though you're not feeling 100%, still here, still bringing our lovely listeners hopefully great recording this week. So
absolutely,
kudos.
Thank you very much, Hayley. Thank you very much. So let's jump back in where we normally start, where you like to name the episode.
Yep.
Okay, so we generally go for Formula 1 drivers. We're back on Formula 1 this week. This might actually be the last one. Oh, no. There is another one in the 30s, actually. But yeah, so we're on episode 33 today, Hayley. Mm-hmm. Do you need some clues?
I certainly do.
Okay. He's from the Netherlands.
Is that Amsterdam?
Amsterdam's in the Netherlands, yeah.
Okay.
He is the son of a Formula 1 driver. And I'll give you this clue.
Is it? Go on.
I'll give you this clue, and this should really help you out. He's he's a 3-time Formula 1 world champion, and very soon could be a 4-time Formula 1 world champion.
So it's Max Verstappen.
It is Max Verstappen.
I was about to say Mick Schumacher. Well then, yeah, I was stuck between the two.
I can see why you got confused, because their fathers,
yes,
Michael Schumacher and Jos Verstappen,
yes,
were teammates at Benetton in 95.
Wow.
So that's probably what you were thinking, wasn't it?
There we go. So where is Michael and Mick Schumacher from?
The German.
Okay.
Yeah.
There we go.
Yeah, I think, I don't know whereabouts in Germany they are, but I'm pretty sure their home karting track was Kerpen. So.
Is there something significant about that? No, just random facts.
Just a random fact that just came into my head. So, yeah.
John knows so many completely random things. We often joke, don't we? Go, wonder what real thing you needed to know that's gone to give you this random fact.
What piece of law is not in my head because you
know the name of the German karting track where
I
Mick
know.
and Mike Schumacher hang.
I know. So anyway, so Max Verstappen, he is currently a 3-time world champion, and this time next week maybe a 4-time world champion.
Wow.
And
This time next week? Is it over next week, or is he just going to win?
no, it's mathematically difficult for anyone else to actually win, and I think the way the maths works out, as long as Lando outscores him by fewer than 3 points, he'll be world champion.
Wow.
So Lando's got to basically win every race and hope that Max just doesn't finish any races, which is
not going to happen, is it?
I normally like to give a bit of a spiel about the driver. I'll say, this driver, he's a good driver. Max Verstappen, I think it's fair to say that he far exceeds that assessment.
Yeah.
Yeah. People that sit there, they question him, is he that good? Is he that good?
Well, the last race where he had to start from right at the back and he still won.
And he still won.
So that should shut up anyone that doubts him.
Yeah, I mean, in the rain he was outstanding. I think 9 of the 10 fastest laps set in that race was set by Max Verstappen. Yeah, I mean, the guy is driving on another level.
Yeah. I mean, he's not my favourite, just because I think he always looks miserable.
Yeah.
Like, come on, you're winning. Be happy.
Yeah. I wonder if it's just, particularly at present, his car's not the quickest car, which is part of the reason why it was so impressive that he won that race from so far back. And probably the other thing is, he's driving with people who just are not on his level. It's like, if I went indoor karting or something and just, on a random day, and you're just with random members of the public and, driving circles around them, and then they hold you up in certain corners because they can't drive that well. It's probably the same for Max Verstappen when he's in Formula 1, even though these are the 19 other best drivers in the world. He's a level above. And
I think as well, he likes the driving and stuff, but I don't know if he likes being famous, and that's kind of the impression I get.
I get that same impression.
Remember when they were at was it Las Vegas last year, and they have to do all this stuff, and he said something like, "I'm not here to perform, I'm here to drive," or
exactly.
something.
Yeah. I have to say, kind of the spectacle of Formula 1's becoming, it is a bit of a show now, because, for many years, it was just, you rock up, okay, it's very glamorous, because, these are the fastest cars in the world, and they've got the top sponsors and all the rest of it, but in the past, it was very much you rock up, you race, and you go home, and you have a bit of a podium celebration. But now they're doing all these, particularly the American races, big introductions, WWE-style intros, the big celebration afterwards on the strip. It's not, 6 years ago before Drive to Survive, this isn't what Formula 1 was about, and I think they've got to kind of appeal to the new audience that's come in.
Yeah, that's it, and they want to make money, don't they?
Well, you've got to make money, and you can't fault them for that.
Everything has to evolve, so to get better, I suppose.
I suppose so, yeah, and it's just, I suppose from my point of view, I was used to.
You think it's just diluting the actual sport a little bit?
Yeah. I think with what the Formula 1 I grew up with and what I'm used to, it was a lot more. What's the word I'm going to go with? I don't know. Maybe small C conservative. And now it's, it's this grandiose, spectacular thing, But, as you say, it's just that's what I was used to. We don't like change. But, change can be for the better. And, in 10 years' time, maybe going, I can't believe how boring Formula 1 used to be in the 90s when they didn't have any of this. So, who knows? But, long and short, it's episode 33, the Max Verstappen special.
Welcome. So, we're going to keep this relatively short-ish, just because you're supposed to be resting and recovering.
Yes.
So, we're going to do an AskSpeedSquad special today, just to get through some of the questions we've got.
Sounds good to me.
I was wondering if you have any advice about getting work experience.
Oh, yeah.
This came from a year 12 student, just to put it in context.
Oh, wow.
So, not someone looking for a pupillage or a training contract, just looking to get some work experience.
Okay, well, the first thing I'll say, if you're asking those questions whilst you're in year 12, you're on the right path. If you're thinking about these things at such an early stage in your career, things are going to go well for you because you're obviously very, very proactive.
Yeah.
So, kudos to you for asking that question. The first point I will make, I think a good number of chambers require their many pupils to be 18.
Yes.
Okay, so that's the first point I'll make. I don't think everyone does, but I think I've heard that's sort of a general policy there, so look out for that. First things first, you can go down the formal route, look for your formal vacation schemes, your formal mini pupilages, fill out the forms.
For the most part, I think you're right, they probably are going to be too young for the formal stuff.
Yeah. So as we say, that's the first thing to think about. You may be excluded purely because of your age.
I think at their level and their age, the main things they should be focusing on is just to get as much of a taster of things as they can. So the formal experiences probably aren't there for them yet, but get themselves down to court and watch as many court cases as they can, figure out what they like.
Yeah.
If they know people that work it doesn't have to be the legal industry, but in any type of industry, see if they can just go down and do a couple of Saturday days and just shadow people and see if they like the business side of things or they don't like that, they like more the court criminal side of things. Just explore as much as you can.
The formal schemes are probably not available to you, but that doesn't stop you from writing into, you're talking about if they got connections, great. If you got them, use them. But if you haven't, then think outside the box. Look for local firms, look for, local chambers, whatever it might be. Write to them. Tell them, what your plan is, year 12, you want to do, as you say, a couple of days or something. And you never know, you might strike lucky, you might get your local high street firm that goes, do you know what, come in with us for a couple of days, come and see what we do. And you get an exposure to, what a law firm is like, or, if it's chambers that'll take you on for a couple of days, you're going to gain some exposure there to see what it's like. You might get an idea for what you're interested in. And once again, it's going to build up your CV as well and build up your connection base. So just because the formal schemes aren't open to you doesn't stop you from contacting other places, other chambers, other law firms, and trying to get in that way.
Yeah. And a good point to make as well is don't be disheartened if you write to a lot and you don't hear back from many or you don't hear back from any. You might not have been exposed to this yet at your young level, but the volume of applications and inquiries that firms and chambers receive can be very, very high. So don't take it personally or, don't read too much into it if you don't get a great uptake of responses. It's, it's nothing against you. It's still amazing that you're doing it and you're showing great initiative for doing it. It's just a very competitive marketplace that you're getting into. And, as John said, you're coming into it from year 12, which is absolutely amazing. So don't be disheartened if it's not as super easy to find the experience. There will be experience out there. You've just got to be resilient and come at it from lots of different ways.
Precisely, absolutely. So you've hit the nail on the head there, Hayley. So enjoy your time. You're not at a disadvantage if you've not done any experiences while you're in year 12, year 13, etc. But if you can get anything, grab it with both hands and make the most of the opportunity.
And speak to your own educational institutions, whether you're in college or sixth form, whatever it might be. They probably will have schemes and connections with companies and law firms, etc. I know when I was at Avon Mitchell, for example, we always took part in, I think it's the Sutton Trust Pathways to Law.
Oh, right.
And that was for high school or sixth form students. They came in and they had a week's work experience with us. So there are schemes out there designed for the younger generation before you're in university, etc. So see what your college or your school can offer you as well. There's lots out there, but can't take for granted what you get from just getting yourself down to a courtroom and watching lawyers in action. So
and the other point that we always make about that is whenever you see any lawyers sort of milling about in the courtroom, not the courtroom, the court building itself, and they don't look too busy, go over, introduce yourself, just say, hi, my name is whatever, I'm a year 12 student, I'm wanting to be a barrister, solicitor, whatever it might be. Can I ask about what you're doing today? Just strike up conversation that way, and who knows where that might lead. You might get a business card, follow it up with an email, and you never know. Yeah, you never know.
And just before we move on, one final thing that we haven't mentioned, which is open to people at this person's level, where they can get some experience.
Yeah.
the Advocacy Club.
Of course, the Advocacy Club open to absolutely anyone. So as a Year 12 student, you're more than welcome to join. And, we've got a really broad membership base. So we've got people at Year 12, we've got people who are starting their legal journey, law degree at GDL, etc. Non-law undergraduates who are looking to transfer. You've got people on the professional courses, graduates, and even people in practice. And that's the point of the Advocacy Club. It's a chance for you to practice and develop your advocacy. And you might find that at your stage, you just want to develop your public speaking, your debating skills. Well, we've got a specific club just for that. If you want to practice specific legal advocacy, you can do that as well. So it gives you the option to practice advocacy online in a low-pressure environment with like-minded people. And we give you all the materials, so you don't have to go off. You don't need to know that type of law inside out. So we give really detailed instructions so that even if you don't know that type of law, you don't know that type of advocacy, the instructions basically fill in the blanks for you, so you don't need to read anything else beyond what's in our very small bundles.
There we go. Hope that was helpful for you.
Yeah.
Next question, which is closely related actually.
Okay.
Any tips or advice on how to make a start and get my foot in the legal industry? So I think this came from an LLB law student, so slightly more advanced than the person we've just been speaking about.
Yeah.
But I think everything we've just said is completely transferable to this.
Well, yeah, all exactly the same, with the exception, you probably are open to the more formal schemes, but they are generally oversubscribed, very difficult to get hold of.
Yes.
I wonder whether this is somebody looking to, maybe they're coming towards the end and looking to get into the jobs market itself. So maybe I'll answer the question from that point of view, just so I'm not repeating the same answer. Yeah. So, when you find that you finish your legal studies and before you're actually going for your training contracts, your pupilages, etc., you might decide, well, I need some experience in the meantime, I need to make some money, let's go and work in the legal industry. So the big job that's out there for most people is that of a paralegal. Sometimes has different names, sometimes you're called litigation executives, I've seen legal assistants.
I was a case handler at first and then they changed it to paralegal.
Yeah. All the same thing, just with a different name. It's like in WWE, how they have the hardcore match and the no disqualification match and the no holds bar. All different things with the same title. So, I like my analogies. Look out for last week's episode where we had the finger and thumb analogy. Yeah. But anyway, the point being, let's say you're at the stage whereby you're looking to spread your wings and get your first legal job. Well, have a look in, just do a little search online for firms that are close to you. They might have a recruitment page. Same point applies. Let's say you see a firm that does an area of law that you like, write in. Have you got any jobs for paralegals? You never know. I found my first legal job advertised in the newspaper. I don't know if people still read the newspaper or not. But yeah, this particular firm advertised in the paper, so I sent them an email and got the job actually. And the other option is to sign up with a legal recruiter as well. Yeah. So they're quite good. So there's two types of kind of recruitment firms. So you got the jobs board type, which is kind of like, I don't really understand how they work properly, but it's effectively just advertises a whole bunch of different jobs. Yeah. And then you got your specific recruiters that they're in contact with firms. So a firm will contact the recruiter and go, right, we've got these jobs. Can you find somebody for me? So if you're registered with that recruitment firm, they've got your CV on file. They go, oh, do you know what? You're a good candidate for this. Let me contact you and put you forward. So get your foot in the door with a few legal recruitment firms as well.
Absolutely. Very good advice there, John.
Yeah, well, thank you very much.
And I think the only final thing I'd mention to get their foot in the legal industry, they also might be talking about building up their connections and networking with people in the legal industry. So advice for that is just get yourself out there. Yeah. There's tons of events. So wherever you're based, so we're based in the Northwest, for example, we're members of our law society. They have events all the time. So they have training events on, they have networking events on, they have their annual dinner and their awards, which is taking place tomorrow. We're hopefully going along to that. John being well enough.
Yeah, fingers crossed.
fingers crossed. He may be there in sunglasses, but hopefully he'll be there. So you get yourself down to that. You never know who you will talk to, and just don't be scared to talk to people and build up the connections. LinkedIn is perfect that this person connected with us and asked this question via LinkedIn. So
you're obviously doing the right thing.
Exactly. So yeah, you never know what connections you might make, and you could be talking to someone at an event about, I'm looking for a paralegal role. Actually, we're looking for a paralegal.
Yeah.
Here's my card, drop me an email. Like, you just never know.
You never know at all. And also, you know, coming back to what we've said previously about, you know, get involved whilst you're at university in terms of, you know, get on your, you know, your law society, bar society, advocacy society, whatever it is you're interested in, get involved, get a position on the committee, and your role might involve outreach to the local chambers, the local law firms, etc. So that's another way that you're building your connection base and building your CV at the same time.
Yep. So there is lots and lots of ways for you to make a start and get your foot in the legal industry. We hope those few ways we've listed were helpful.
Yeah.
Okay, so this was a question I got, but I am going to need your assistance to answer it, John.
Okay, go on.
So, as a commercial solicitor, have you ever represented someone in a courtroom or tribunal? No.
You've got experience of one piece of advocacy, haven't you, Hayley?
Oh yeah, I am undefeated in the High Court.
Oh yeah, tell them all about it.
So I had to make an application to restore a company to the register, and I remember when I was a trainee, I was so nervous. I had a script. John was trying to help me practice, and I was like, "No, you're making me more nervous, John. Leave me alone." I had this whole thing planned. Goes in there. Judge says, "Do you have a draft order?" "Yes." "Would you like me to stamp that?" "Yes, please." "Here you go, stamp."
Boom, easy. I've done that same piece of advocacy once. When I was coming towards the end of my time while I was paralegaling, so I used to do the employer's liability and public liability stuff, so accidents at work, slip, trip, etc. And there was an adjacent team that worked adjacently to us who did industrial disease, so a lot of that was noise-induced hearing loss. And most of the companies they were suing were companies that were operating in the 60s, 70s, 80s, etc., so they didn't exist anymore.
Yeah.
So so quite often they would have to restore that company to the register so they could sue them.
Yeah.
So I did the same thing, went to court, and mine was a very, very similar experience as well. So yeah, but to answer the question...
Well, hang on, there's more to the question.
Oh, sorry, go on.
So I'll finish first, but
Yeah.
I'll just finish by saying, so my background, so as people know, commercial solicitor, now a legal director. I worked in private practice in real estate disputes, property litigation, which is all the same thing, just different names. So my experience, I was sat behind the desk or behind the advocate, barrister in court. I didn't do any advocacy as my role, and I was very happy about that. Very happy about that. Though I do always say, if advocacy club and stuff had existed when I was a junior or when I was a student, maybe I would have turned into a barrister and found a love for public speaking. We will never know.
Who knows?
But yeah, the next part of the question, John, which is what you can help me with particularly, would you say that the type of advocacy used is different compared to other areas of law? So commercial style advocacy and we'll say the more common, the more well known, so the criminal and the family law advocacy, etc.
Okay, so as you say, it depends on who your tribunal is. So when I talk about some of my criminal cases, whenever I've got sort of interim hearings, so it might be a first appearance or a case management hearing, whereby what you'll do is, or PTPH for that matter, your client gets arraigned or the charges read to them, they'll enter the not guilty plea. You'll explain to the court, well, these are the issues. This is the reason that my client has entered a not guilty plea. Given the issues, these are the pieces of evidence that we want to see from the prosecution. It might be that it involves expert evidence, so we say, we're going to be requesting an SFR2. These are the directions I would suggest. These are the witnesses that are going to give evidence in trial, and given the time estimates, I would expect that the trial will be 2 days, 2 hours, whatever it might be. So that style of advocacy is directly transferable to a lot of your interim hearings in a civil court as well. So from my point of view, a case management hearing or case management conference, as you call them in the civil world, is almost identical
Yeah.
to that of a case management hearing in the criminal court. The style of advocacy used is the same because it's very matter of fact. You're just telling the judge, these are our submissions, these are our views as to how the case should go, these are appropriate directions, etc. Now, you may find that you get some adversarial advocacy at some of these hearings as well. So it might be, for argument's sake, in the civil court, you might be arguing about whether a piece of evidence should be disclosed. So let's say you've filed your list of documents. I'll get the sections of the CPR wrong on this because I don't do civil anymore, but long and short, let's say you do your list of documents and you find out that the other side have got a piece of information, a piece of evidence that you want, well, it wouldn't be evidence, but, something from the list of documents, you want to see it, and you end up with an argument in court over whether or not that evidence should be disclosable. Likewise, you might have a situation in the criminal courts whereby the prosecution send its disclosure schedule, you see a piece of information on there that you think, well, we're entitled to that because that potentially may undermine the prosecution's case. They dig their heels in, they don't want to send it, you serve a Section 8 application, you have an argument in court. Once again, the advocacy on that will be very, very similar because you're arguing over whether a document should be shared and you're in front of a judge. So there's not going to be a million miles of difference between the two. Where the difference comes in, I think, is trial advocacy, number one.
Yes.
Because if you're in the magistrate's court, you're arguing in front of lay magistrates, lay members of the public. Although they're there day in and day out, you can be a little bit more, theatrical appeal to their sort of human side. And then once again, when you're in the Crown Court, the way you question witnesses in cross-examination, you've got to remember, you're not asking questions for the answer, you're asking questions for, or not always, sometimes it's the implication with the question. You might be saying, well, why did you not do this? Doesn't really matter what the answer is. It's more for the jury to think, hang on, why did that person not do that?
Yeah.
And likewise, when it comes to your closing speech, that's your chance to really be theatrical, throw in all your rhetorical questions, use all of your facets of public speaking to really present that. You wouldn't be that theatrical if you were doing a closing speech in a rear-end shunt RTA trial in front of a district judge. It just wouldn't be the same because, you're not trying to... a district judge is very different to a jury.
Yeah.
For obvious reasons. So that's the key difference, the trial advocacy. And to a point, when you're doing bail applications and pleas and mitigation, even in the Crown Court in front of very experienced Crown Court judges, once again you're trying to bring out the personal side of that person. What is their personal mitigation? What's their background? Why did they commit that offence? Likewise, when they're on bail, you're trying to show, let's say they've breached bail conditions in the past and the prosecution have got a real concern that this person is going to fail to surrender, and you're trying to show all the things that they've changed, why this person is a changed person, why this person wouldn't be breaching their bail conditions. Once again, you're kind of trying to tug on the heartstrings a little bit, which isn't really something that you would do in a civil trial.
No.
Civil trial, although it involves real people, let's say it's a personal injury case or something, it's still, how does the evidence fit the facts?
Yeah.
So that's the key difference, I would say. But with the exception of your trials and with the exception of your kind of personal hearings, I'll call them, your bail applications, your pleas and mitigation, advocacy's advocacy.
Yeah, no, I agree. And I think from the hearings that I've witnessed, so the civil hearings I've been to and sat behind barristers and then watching you do your stuff as well, John, which obviously is the criminal stuff, I think that's the biggest distinction I would make as someone that isn't an advocate, is just the criminal side of things. It's just so much more theatrical and dramatic. The civil stuff, it just feels more like a conversation with another person, a conversation with the judge. So even interim hearings and stuff, as you say, the judge will have read the file, will know the case. They might be with the appellant or the respondent on everything, but they're like, I'm just not convinced about point 4. Convince me about that. I don't want to hear about the rest of the stuff. I already know what my decision is. Or just recap it for me. Yeah, I'm with you. Or what about that point? Okay, what do you say? Okay, well, what do you say back to that? Okay, I've made my decision. Here it is. Where in the criminal trial, the judge, again, might be there, know all the ins and outs of the case, but when you've got a jury there, you've still got to take them through it step by step by step.
Yeah.
And yeah, it is a bit of a performance, isn't it?
Yeah, and I suppose as well, you can make certain assumptions to an extent, even at trial in your civil cases, because the judge knows what the legal tests are,
exactly.
knows what the burden and standard of proof is, and so you don't need to spell things out as much. In the Crown Court, what we do is, before we move on to closing speeches, we'll agree sort of a route to verdict for the jury. So because juries don't understand a lot of our legal concepts, a lot of lawyers struggle to understand them, so they're not the simplest things. So for example, you'll break it down, and for each count on the indictment, you'll say, here's the route to verdict. So it might be just a 3-stage process. So here's the first thing we need to prove. If you're satisfied of that, move on to, well, if you're not satisfied, not guilty. If you are satisfied this is proven, move on to question 2. And once again, it'd be a really simple question about the evidence. If you find that that's satisfied, move on to question 3.
Yeah.
If your answer to all 3 questions is yes, then you convict. So that's how we'll all agree between the prosecution barrister, the defence barrister, and the judge, what that route to verdict is going to be for the jury. And then you can kind of craft your closing speech around that anyway. I mean, you will have, you're going to have a rough idea beforehand anyway, so a lot of people like to type their closing speeches before they even begin the trial. But with that in mind, once you know what the parameters are, once you know what the agreed route to verdict is, you can kind of incorporate that within your closing speech as well.
Yeah.
So the point I'm making there is, you do have to spoon feed the jury a little bit, really make things a little bit simpler. Once again, just because they're not legally trained people, or we can assume they're not legally trained anyway. So we just need to make things nice and simple for them.
There we go.
There we go.
So I hope that was helpful. As I say, even though I've not represented someone in a courtroom or tribunal, I think we still give a nice, well-rounded answer to their question.
Hopefully.
A little insight into how that type of advocacy compares to others. So, final question, which is a practical question.
Okay.
So, this person says they are doing a plea in mitigation, but a PSR, which is a pre-sentence report, was not given. Should they address the court as if there is one, i.e. should they be creative, or should they just use the papers that have been given?
Okay, well, the first piece of advice I'm going to give is something that goes for all forms of advocacy competitions. Read the instructions very carefully and read the facts very carefully.
Yes.
And if they say, these are the parameters, these are the, limits of the facts, don't make extra bits and bobs up just, to assist, if that makes sense. So how that applies in this situation, if the bundle says there is no pre-sentence report, don't make one up. Or if it's silent on the point, don't assume that there is one.
Yeah.
Now, I imagine this person's probably entered one of our competitions before where we tend to include pre-sentence reports in our pleas and mitigation. Or I think every competition we've had has included a pre-sentence report, and therefore maybe thought, well, hang on, it must be required. A pre-sentence report isn't required for every single sentencing hearing.
Yeah.
So the pre-sentence report, just to give a bit of background, just in case somebody's not come across this before, when you have an individual that's to be sentenced, so they've either pleaded guilty or been convicted of an offence, the pre-sentence report is completed by the probation service. So probation will meet with the defendant prior to sentencing, so it could be on the day of or it could be on a random day beforehand. They will ask a series of questions to that person about their life, so they'll ask them what their view is on the offence itself. So probation can give a bit of an opinion on whether or not they think that person is remorseful. They will ask them about their personal life, so what they do for work. Do they have any financial problems? Do they have massive debts? Do they have any issues with regard to drink and drug? Any dependencies there, etc. They'll ask about their family. So they'll ask about, what roles and responsibilities they take within the family. Do they have any caring responsibilities? Do they have dependents who are reliant upon them? And a variety of other questions as well. And the purpose of this is so that the probation service can make recommendations to the court as to what that person is suitable for. Because when it comes to sentencing and the punitive element of a sentence, there's generally a few options open to the court. So financial penalty is the least draconian, and if ever somebody was facing an offence whereby they could only be fined, well, there's no point in having a pre-sentence report because you don't need probation to comment on whether somebody can be fined. If a community order is open to the court, well, this is really where you need probation, because they need to make recommendations to the court as to what that person is suitable for.
Yeah.
So when you've got a community order, the most common punitive element to that is unpaid work. Community services, you've probably heard in the past, so unpaid work. So probation will say, yeah, this person's physically fit, we think they can complete unpaid work, or they might say, no, due to physical or mental health concerns, this person just would not be suitable for unpaid work. Or it might be that given how many hours they work, given their familial responsibilities, etc., they just wouldn't have the time for unpaid work. So they'll comment on that. They would comment on whether the person would be suitable for a curfew, and that's a tag that keeps them in the house from 7 o'clock at night or 7 in the morning or whatever it might be. They'll comment on whether they would be suitable for what we call RAR days, Rehabilitation Activity Requirement days. They comment on whether they need maybe a mental health treatment requirement or an alcohol treatment requirement or a drug treatment requirement. So basically it's the purpose of probation to comment on whether they're suitable for any of those things. And then lastly, if the court is considering a custodial sentence, so this is what we call an all options report.
Yeah.
Probation can't be recommending prison. They never recommend prison. But what they can say on the other hand is, they would say, if the court is minded to suspend the sentence, we would be happy with that because we think that this person is a suitable candidate to be managed in the community. Meaning, if they don't go to prison, they're not going to be a complete menace to society. This person is safe enough that you can give them a suspended sentence, and probation can comment upon that. So that's your purpose of the pre-sentence report. So it might be in your scenario, there is no pre-sentence report for a reason. Either it could be only a fine is suitable is the only available remedy to the court. It might be it's so serious that only a custodial sentence is suitable. So you might have, a very serious Section 18 whereby community orders aren't even on the table. You're only looking at 5 years plus whatever. So what's the point in a pre-sentence report if they're going to prison anyway? It might be that this person has a very long criminal history and they've had pre-sentence reports in the past, and it's, well, what's the point in having a pre-sentence report on this occasion again? So there could be reasons that it's not included. So don't make up that fact about a pre-sentence report if there's no reference to one.
Yes.
Okay, so read the papers again, just check whether this is a case whereby there would or wouldn't be a pre-sentence report. And if there's no reference to it, don't assume that there is one, so don't be making reference to the pre-sentence report.
Yeah, and if your instructions say you can only rely on what you've been given, you might hurt your chances in the competition if you start making things up because you're not following the instructions.
Yeah, and as I say, that spreads beyond because, I've judged moots where people are making reference to things that are not in the bundle. I say, where did that come from? Oh, well, I just made that up. No, never assume. If something's not in there, it's not relevant. Yeah. So don't.
And if you're really stuck, so you've answered all these questions that John's put to you and you're still not sure, ask whoever's organising the competition.
Yeah.
I'm sure they'll be able to answer.
100%, yeah. If something's unclear, always go back to your competition organisers and ask the question.
Yeah. There we go. They are our Ask Speed Squad questions for this week.
Perfect. Well, I think that brings us towards the end of the podcast, Hayley.
I think it does, John.
Couple of round-up bits to talk about. The National Pupillage Fair is taking place on the 23rd of November.
Yes.
We will be there, so we have our own stall. We'll be exhibiting. And on top of that, I'm doing a talk on the day. I'm doing an advocacy exhibition, so you'll get to hear me talk all about advocacy, give some tips, and you even get to watch me do a performance as well. Ooh. So that's at Lincoln's Inn on the 23rd of November. Highly recommend you get yourselves down there.
Absolutely.
If you're not local to London and it's not feasible or practical for you to get to London, or you simply just aren't available on the 23rd, don't worry. Our Northern Pupillage Fair is back in 2025. So you'll be able to attend that next year. So you'll be able to meet us then. And also, we've got another big event coming.
We certainly have.
We are doing the big launch on the 20th.
A week today.
So a week today. So we're recording this on the Wednesday. Obviously, you get this on the Friday. So Wednesday of next week, the 20th of November, 8 o'clock in the evening, everyone on our mailing list is going to get an email with a link to the sign-up page for this event.
Yes.
If you're looking for pupillage, you really can't miss this event. It's going to be a massive help to you, and it's completely free.
Yes.
So, but places are going to be snapped up quickly.
I think our mailing list would probably take all, if not 90% of the places before it goes public.
Yeah, I think so. So if you want to benefit from this event, get yourself on the mailing list.
speedmooting.com/contact.
Yeah.
Simple.
So that brings us to the end of this episode, the Max Verstappen special. I've enjoyed recording it. Have you enjoyed recording it, Hayley?
I've enjoyed recording it, John.
And if you're still listening at this point, you are one of our real listeners. So what I would say is drop a comment down below if you're still listening at this point. And the comment this week is World Champion.
World Champion.
In honour of Max Verstappen. So we'll see you next week. Bye.
Bye.